matter of Seerangan and the Secretary of State for the Home Department.
My Lords, my Lady, I appear for the appellant this morning with Ms. Jagiraja. My learned friend, Mr. Holman, appears for the Secretary of State. I'm very grateful for the email yesterday about this court's judgment in Falk.
Yes, although, as sometimes happens, I'm afraid, you're too polite to say so, judges in their pre-reading think something might be relevant. My present view is that it probably isn't.
Yes.
But, so don't feel obliged to deal with it unless you've seen something there that I haven't.
No. I'm very grateful. So, what we have done, my Lord, with apologies from our end, is that we have printed copies for the court with page numbers. So may I respectfully ask you to perhaps put it at the end of the authorities bundle or elsewhere, wherever it's convenient.
Yes, thank you. We will. The bonus, I say, I did.
Yes.
Thank
I'm grateful. So unless there are any other matters, I will make a start. So as
yes, sorry, just one. What is, if you look at the papers, your client's name sometimes appears as if the name under which it's listed, which is Seerangan, is his first name.
Yes.
Sometimes as if it's his family name, and you can find both versions equally spread. But what is the definitive answer? Is he Mr. Seerangan or Mr.
The surname is Seerangan.
Oh, it is. Okay.
Yes.
Fine.
So as my lady and my lords know, the pandemic was an unprecedented event. It led to closure of borders, businesses, and educational institutions. It affected everyone in the country, but the way in which it affected international students and workers was quite substantial. Many international students were not able to complete their studies. Many workers were not able to continue with their jobs. Many of them found themselves to be in breach of immigration law, including overstaying their visas. Now, the Secretary of State, for obvious reasons, does not like anyone to overstay in the country. She has, over the years, formulated immigration rules discouraging overstaying, and those rules include provisions which provide that an application for leave to remain will be refused if a person is in breach of immigration law. But the Secretary of State appreciated that the circumstances during the pandemic were truly exceptional. So she sought to relax the requirement of the immigration rules through various policies and letters. And this case is about the effect of the exceptional assurance policy and the assurance letter provided to the appellant. It also raises a question as to the proper construction of paragraph SW 2.2 of the immigration rules. Now, the facts are not in dispute. The facts are set out in the skeleton arguments. The appellant's case is a paradigm case, and many others are in the same position. He was an international student. He had leave to remain from 24th of September 2020 to 30th of January 2022. He spent thousands of pounds to come to the UK to study for a postgraduate qualification. He wasn't able to continue his studies during the pandemic because of the adverse effect of the pandemic. He wasn't able to make an in-time application for leave to remain, and
Why
he
wasn't he able to make an in-time application for leave to remain?
because of the adverse effect of the pandemic. He made a witness statement that is in the papers. But so far as
well, I have not picked up, and certainly that my fault, was anything. I thought that he was simply an overstayer from the 30th of January 2022, and the reason why he was an overstayer isn't really relevant. On the the face of it, he could have made an application before the 31st of January 2022 for leave to remain on any available basis
Yeah.
there was. Or if he was wanting to go home but couldn't because at that point there were problems about going, he could have applied for an acceptable assurance, but he didn't do either.
No.
So he's an overstayer.
Yeah.
That's
So-
the end of that.
Yes. So the reason why he became an overstayer is not relevant to the issues of law that the court will decide. But he has explained in the evidence as to the circumstances of the overstaying. Just given that, my lord, you have raised the point. Can I just highlight this at a general level? So if educational institutions are closed, if businesses are closed, at a general level, it is difficult for a student to get sponsorship and to then make an application for leave to remain with that.
That's everyone's misfortune because
It is, yeah.
If there aren't jobs available, then you can't apply on the basis you've got a job.
No.
And if courses aren't available, you can't apply on the basis you've got a course. That's straight line.
It is. So nothing
As a
does
matter of chronology for the appellant, I think he entered after the pandemic had started, in the
yes.
first sort of release from lockdown.
Yes. So 24th of September 2020
Yeah.
is the date when he was granted leave, and he became an overstayer on 31st of January 2022. Now, he became an overstayer for some time, and he applied for exceptional assurance on 14th of November 2022. He was granted an assurance on 16th of November 2022, and that was valid until 30th of November 2022. And before expiry of that assurance,
Was he granted exceptional assurance? He was granted an assurance.
an assurance, yes.
I'm sorry, the reason I'm not being picky, but it's worth just taking this point now. There appears to be an exceptional assurance granted under the policy,
Yes.
taken under the policy, which is effectively to regularize your position until you can go home.
Yes.
Short term, because it's expected you'll be able to go home soon.
Yes.
He didn't qualify for that.
Yes.
He didn't therefore get an acceptable assurance under the policy. He got a separate kind of ash thing, confusingly described as an assurance, but not
Short.
as an acceptable assurance.
Yes.
Confusingly described as short term, but not short term in the same sentence. But was simply time to pack up. Can we call that a packing up assurance?
Um,
And that's all he got. So I'm sorry to pick you up, but
Yes.
It's taken me some time to work this out.
Yes.
We're quite sure we're on the same page about this.
Yeah. I will, I'm afraid. We'll have to address you further on this point.
Okay, well, I'll wait to hear that.
And I of course, I do not accept with this fact that it was simply an assurance to pack up. Yeah.
Provisionally think, so you'll be able to address it.
Yes. I'm
Keep
good.
going, Mr. Alexander.
So the point is, for the purpose of introduction, is that he made an application for leave to remain before expiry of that assurance, and that application was made on 29th of November 2022. The Secretary of State refused that application on the basis that he was in breach of immigration law, and that is the decision that gave rise to these proceedings and the upper tribunal's decision that is subject of this appeal. So subject to any observations, what I propose to do this morning is to address you first on the immigration rules, then on the effect of the policy, and then on the individual assurance given to the appellant. I will then take you to the decisions made by the Secretary of State and the upper tribunal, and will make brief submissions about those decisions. So first, immigration rules. The ultimate authority, as the court knows, as to the proper approach to be adopted in construing immigration rules is the judgment of the Supreme Court in Mahad. That judgment is behind tab 8 of the authorities bundle. tab 8 of the authorities bundle, page 126. The issue before the court was about the construction of the maintenance provisions in the immigration rules. So may I ask my lady and my lords to look at page 130 of the bundle. At the outset, my lady and my lords will see the relevant rule, and you'll see that the relevant rule, subparagraph 5, provided that the parties will be able to maintain themselves and any dependents adequately without recourse to public funds. Now, this court had decided that third-party support was not available on true construction of this provision. And the issue before the Supreme Court was whether that construction was correct. Paragraph 10 of the judgment, this is the judgment of Lord Brown, page 132. You'll see that there he referred to MO Nigeria and approved a quotation from that judgment. The construction of the rules depend upon the language of the rule construed against the relevant background. And that involves, on the next page, considering immigration rules as a whole. So you look at the language of the rules, but you look at the rules as a whole as well. And then if you look between letters B and C at page 133, the rules are not statutes or statutory instruments. They should be construed sensibly. And the question, the ultimate question is what the Secretary of State intended his policy to be. This is the approach that Milady and Milords will apply in reading the immigration rules. Now, later in the judgment, Lord Brown identified what in my respectful submission is a useful tool to ascertain the true meaning of the immigration rules. And that is the tool that I would respectfully invite the court to deploy in this case. Now, can I take you to page 137 of the bundle? And if I may ask you to look at paragraph 26. So there, Lord Brown referred to a number of other immigration rules, the rules that expressly excluded third-party support. And you'll see references to those rules at paragraph 26. And it's quite clear that third-party support was expressly excluded in relation to those rules. If you then look at paragraph 28, you'll see that Lord Brown sought to compare the language of the rule in question with those other rules and made a point that if the Secretary of State intended to rule out third-party support, then that is the sort of language that she would have used. So it is entirely legitimate to compare and contrast wording of different immigration rules to ascertain the meaning of the rule in question. And that is how I would respectfully invite Milady and Lords to approach the rules in question. So can I then take you to the rules, and what I will do is to seek to take you through the rules in a chronological order, so that makes more sense. So tab 1 of the authorities bundle, you have paragraph 6 of the immigration rules. That paragraph concerns interpretation of certain provisions. And if you look at paragraph 6.2b, you'll see that it says that unless contrary intention appears, the following definitions would apply.
Sorry, I'm not which page?
Page 2 of the authorities bundle, just behind tab 1. page 2. If you then look at page 4, you'll see the definition of the phrase breach of immigration law. And you will see that the definition is expressed in present tense. A person is in breach of immigration laws for the purpose of these rules, where the person is an overstayer. Is an overstayer. You'll then see that there is a different phrase that is then defined, previously breached immigration laws. And you will see that that provision is defined in past tense. A person previously breached immigration laws if they overstayed. So there is a clear distinction between, in the immigration rules, between present overstaying and previous overstaying. The phrase overstaying is also defined in this section, and that definition is at page 15 of the bundle. Overstaying means the person has stayed in the UK beyond the latest of the time limit attached to the last commission grant. If you then go to tab 2 of the authorities bundle,
Out of curiosity, I see that permission has been defined as being the same as leave to enter. Is that a new change in the rules for use of that permission?
it is, yes.
When out of curiosity, when it became some education?
Well, it was introduced following the law commission recommendations to, yes, to simplify the immigration rules. It was felt that the concept of leave to enter and leave to remain was causing confusion and ought to be replaced by a single phrase permission.
Oh, interesting. Okay. Well, thank you. I didn't know that. Right.
Yes.
Okay.
So tab 2 of the authorities bundle, you have part 9 of the immigration rules. And if I may take Milady and my lords to page 34 of the bundle, I'd ask you to look at paragraph 9.8.1 and 9.8.2. You'll see that 9.8.1, it falls under the heading previous breach of immigration laws. It says that an application must be refused if the applicant has previously breached immigration law. And you'll see that previously breached immigration law is a phrase that is also used in 9.8.2. So when the Secretary of State intends to have a rule addressing previous overstaying, this is the language that she uses. She says expressly that a previous overstaying would be a disqualification. There are many other provisions in this part relating to previous overstaying, but the example given in 9.8.1 and 9.8.2 is sufficient for the present purpose. If you then go to tab 5 of the bundle, you'll see paragraph 276B of the immigration rules, the rule that was considered by this court in Falk. If you look at subparagraph 5, it says, you see that it is in 3 parts. Part 1 says the applicant must not be in the UK in breach of immigration laws. You'll see that that relates to present or current overstaying. There is then, the second part is about the exception, and the third part says any previous period of overstaying between periods of leave will also be disregarded. So there is a distinction again between present overstaying and previous overstaying. The fact that the words the applicant must not be in the UK in breach of immigration laws relate to current overstaying is, I hope, uncontroversial, and it's quite clear from the language of the rule itself. But this is what this court said categorically in Hoth. If you need the reference to the relevant paragraph, it's paragraph 31 of Hoth.
I wouldn't have thought it's necessary to go to.
No.
I can't believe it should dispute.
No. So 31 says that, well, these words relate to current overstaying. And these are the words that appear in the rule in question 2. Now finally, if you then go to tab 3 of the authorities bundle, you'll see the rules relating to skilled workers. And the suitability requirements are at page 44. Now you will see that the relevant paragraph, paragraph SW 2.2, uses the same language as in paragraph 276B5 so far as relevant. It says if applying for permission to stay, the applicant must not be in breach of immigration law. There is, in my respectful submission, no doubt that this is about current breach of immigration law, the breach as at the date of the application. Previous breach of immigration law is not a disqualification.
Why not under 2.1?
Well, yes. So 2.1 says that an applicant must not fall for refusal under Part 9. Now, it is common ground that the appellant does not fall for refusal under Part 9 of the rules. The Secretary of State took that point in the decision that she made, but she very properly abandoned that point at the upper tribunal. If you want me to elaborate on that.
Yes,
Yes.
forgive me for not having concentrated on this point. Why wasn't it a ground for refusal that he was past it was there?
Yes, because Part 9 of the immigration rules does not contain a disqualification for past overstaying so far as the application for leave to remain is concerned. The provisions that I've shown you concern entry clearance. So past overstaying, the Secretary of State's policy is that past overstaying is not a disqualification if she has granted leave to remain, if she has subsequently granted leave to remain to the person.
Okay, thank you. That's very helpful.
So an applicant, in my respectful submission, cannot be refused because of historic or past breaches of immigration law under paragraph SW 2.2 of the immigration rules. That is, in my respectful submission, a sensible construction of this provision, a construction that is supported by the authority and is in accordance with the natural and ordinary meaning of the words used. It's also consistent with the immigration rules read as a whole. So these are the relevant rules. If I may now address you on the policy. Now, can I take you to two authorities as to the effect of the policy, and I'll then take you to the policy itself. Now, it happens, as Milady and Milords would know, that the Secretary of State would promulgate policies that are not entirely consistent with the immigration rules, or policies that would sought to relax the requirements of the immigration rules. Now, this court considered the effect of such policies in Pokreal. This is tab 9 of the authorities bundle. now, Milady and Milords may recall the provision which provided that if an applicant makes false representations in an application for leave to remain, whether or not to the applicant's knowledge and whether or not material to the outcome, the Secretary of State would refuse the application for leave to remain. This is what the rule in question said. But the relevant minister made a statement, sent a letter to ILPA saying that the rule is intended to catch those who are dishonest and is not intended for those who make innocent mistakes in their applications. But the rule said something different. The Secretary of State, despite that statement and assurance, started refusing applications for leave to remain, even where the application would contain an innocent representation that is inaccurate. The court read down that rule in the light of the Secretary of State's statement and the assurance. If I may ask you to go to page 154 of the bundle, and if you look at paragraph 42, you'll see that Lord Justice Jackson says that if there is an ambiguity in the immigration rules and the Secretary of State publicly declares that he or she will adopt a more lenient interpretation, the courts and tribunal may hold the Secretary of State to that assurance. And you will then see a reference to Edidoyan, the case about making of false representations, and you will see that the rule was effectively read down in a way that wasn't consistent with its language in the light of the Secretary of State's published guidance and statements. Of course, that is not a permissible tool to construe a statute or a statutory instrument, but when it comes to the construction and effect of the immigration rules, it is entirely legitimate to look at the rules together with the Secretary of State's policy and assurance, because the rules are not the law of the land, they are statements of the policy. There is one exception to that principle, and that exception is at paragraph 43. So although an applicant may rely on extraneous documents to persuade the court or tribunal to construe a rule leniently or to disapply the rule, that isn't an option available to the Secretary of State. That is based on what the Supreme Court said in LV. The Secretary of State drafts the immigration rules, issues policy documents, and she cannot toughen up the rules otherwise by making a formal amendment and laying them before Parliament. Now, Pokhriyal was about the meaning of the phrase academic progress. This is paragraph 45. And the court again read down that rule in the light of the Secretary of State's assurance and guidance, and said effectively that the Secretary of State cannot go beyond the assessment of an educational institution of academic progress. Is paragraph 47. So one effect of the policy is that it affects the construction of the immigration rules. It affects as to whether a particular rule should be read down in a particular way, or should be construed more leniently, or should be disapplied in certain circumstances. The second effect of the policy was considered by the Supreme Court in Mandalia. Again, the court is familiar with the authority. It's behind tab 7 of the authorities bundle. This case was about the evidential flexibility policy the Vice President knows about. I suspect my Lord knows about that as well. So the Secretary of State formulated immigration rules saying that she will refuse an application for leave to remain if certain documents are not submitted. But she published a policy entitled Evidential Flexibility, stating that if certain documents are missing, she will not refuse the application outright, but she will invite the applicants to provide or to submit missing documents. So there was a tension between the rules and the policy, and the Supreme Court considered the effect of the policy. If you go to page 122 of the bundle, just above paragraph 29, you'll see a heading, the legal effect of policy. And if you look right at the end of that paragraph, which is at page 123, Lord Wilson makes a point that there is now a freestanding public law right to be dealt with under the policy, whatever policy the executive feels is appropriate.
Sorry, which paragraph is that?
This is paragraph 29.
Thank you
It starts at page 122, and the point that was made is made at the end of that paragraph, page 123. You get that from the Supreme Court's judgment in WL. This is paragraph 30. And then 31, when it comes to the construction of a policy, it is for the court to decide what a policy actually means. So this is the second way in which a policy has an effect. It has a freestanding effect. So if the Secretary of State has said in a policy that she would disapply a particular provision, then the Secretary of State is bound by it. Now, can I then just take you to the policy? But perhaps before I do that, can I just show you what the Secretary of State says her policy was at the time? And if I may ask you to look at the co-appeal bundle. Page 90. Page 95. Now, if you look at, this is the Secretary of State's pleaded defense. If you look at paragraph 7, you will see that it refers to the witness statement of Mr. Shirley, the defendant's witness. The witness statement is in the supplementary bundle. If you look at page 96, you will see that the policy was in two phases. The first period, the first phase was from January 2020 to 31st of August 2020, and period 2 was 1st of September 2020 to 30th of November 2022. Now this appellant falls in period 2. And that is the period when exceptional assurance concession applied, and that also included short-term assurance. Now, what was the effect of those policies is set out at paragraph 9. So period 2, the Secretary of State says, reflected continued policy response as to COVID-19 pandemic, as COVID-19 pandemic persisted and developed. Now, there is a reference to the purpose of the exceptional assurance concession. But if you look at the middle of that paragraph, line 7, during period 2, the Home Office no longer issued automatic extensions to a visa, but instead assurances to individuals upon application, which when granted, would give them a short temporary period of permitted stay in the UK. Now this is correct, and this is what the Secretary of State says her policy was, and in my submission she is right. If an assurance is given to an individual, that assurance on the Secretary of State's policy is permitted stay in the UK. It isn't a grant of leave, but it is something very similar, because it protects people in the UK from being treated as an overstayer when they could not leave due to the impact of COVID-19. Standard letters were sent, which advised the holders to make plan to leave the UK, and this answers the question that Lord the Vice President asked when I started my submissions, or to apply for permission to stay or remain in the UK. So the assurance wasn't simply a sort of pack-up assurance to enable.
Yeah, but that's before their acceptance assurance period ended.
Yes.
In the present case, we'll come to this in a minute, so you feel the point is, the present case, there was no acceptance assurance period.
We'll come to that. Yes, but my submission is that there was, and I will explain why that is so. So short temporary period of permitted stay. Now, if you then go to page 99 of the bundle, now this will tell you the difference between the exceptional assurance and short-term assurance. Now, short-term assurance, this is paragraph 14. So the position was that where travel restrictions were in place, the assurance would be for 10 weeks. Where there are no restrictions, the assurance would be for 2 weeks. So that really.
Right, but that language does make the distinction I've been making to you.
Yes.
There are travel restrictions in place.
Yes.
You get a 10-week exceptional assurance.
Yes.
And if there aren't, so your request for an exceptional assurance fails.
Yes.
You're just given 2 weeks grace to pack up.
Yes.
It's called something different.
Yes. But that, yes, of course, I recognize that this is what it says. But when I'll take you to the policy and the assurance letter, I shall seek to demonstrate that the policy was that both assurances operated in the same manner. The only material difference was that one assurance would be for 10 weeks, the other would be for 2 weeks. But the assurance was for 2 weeks, wasn't to pack up. It was also to pack up or, in addition, to make an application for leave to remain.
It's page 223.
Yeah, so the concept of permitted stay relates to both species of assurance. So this is the evidence as to what the Secretary of State policy was. The policy itself, there are various versions, but the relevant version is in the supplementary bundle at page 85.
Is this the document to which, if you had followed the link in the letter, you would have been directed?
Yes, I think so. This is
Yeah, the link is at 223 as well. I'll open it up.
If you look at the second page on page 53 of the main document, it says the exceptional assurance policy as outlined at, and then there's a hyperlink. And the title appears to be exactly the same. So I'm assuming, and I think the quote. Let's track it down. Well, I did, but I haven't marked it down stupidly. The quote in the next two paragraphs of the assurance letter can be found in this document.
yes. My understanding is that this is the policy that the link would take you to.
Yes.
That's my understanding. I mean, it's difficult because, of course, it's now on the National Archives, not the link doesn't exist
Well,
anymore.
not that difficult. You're the Home Office. You can
Yeah,
can,
yes.
and should, have produced
Yes.
the document in the form. I think that's what he says it is.
No, no,
Well,
it
I
is.
wasn't
It is.
expecting it to make difficult. It's to make quite sure.
I
That's-
don't think it's
that's-
precisely the right version, because this version on page 86, towards the bottom, refers to expiring on 31 October, whereas the letter
That's
has
well
gone to
responded,
30
yes.
November.
No.
If my lady had been more diligently, I just noticed 35, so last updated 26 September 2022, and I assumed that was the latest one, but my lady must be right.
Yeah, there must be a further.
It's a bit lazy, isn't it? Shouldn't we have the version that...
Sorry, you have to help me there.
Towards the bottom of page 86,
Yes,
now the last full paragraph,
yes.
something that the exception assurance expires before 31 October, whereas by the time the letter is written, it's 30 November. Look at the quotation in the letter.
Yeah.
Well, I think I'll just double check this.
Because I think they must have pushed it back by now.
They were updating pretty regularly.
They were.
And as my lady says, almost certainly, if only to make sure the dates kept up to date. We haven't in this case. With some of the other policies, we got all the updates. This one we haven't. Well, look, I think on any common sense view, this must be right. As I said,
Yes.
I think
Yes.
we really could have been given the exact document.
I see the point. Yes, I can't say why that is so. It is sometimes challenging these circumstances because you only have when the National Archives saves the website.
So,
Yes,
yeah,
you only
sorry.
have when the National Archives save the website. So practically speaking, it can be challenging. Maybe this was the closest that could be found on the day.
Surely the Home Office
But,
keeps by or in full, even if it doesn't require the National Archive, every document that it puts up. If it doesn't, that's really serious for the rule of law.
Well, as I say, it's it may be I'm sure. Well, indeed, I'm sure there is a version that can be obtained, but this has been obtained from the National Archives website for time.
Well, I think if only as a discipline, you can take more careful in the future, and it's behind you more careful. Could
Yes.
we have the actual version?
Yes.
We will in the meantime proceed, which must be the case, that it's
Yes.
the same except for the date. And I think it's a healthy discipline always to give us the actual.
I agree, and I hadn't noticed the discrepancy, I'm afraid.
Nor had I, but my lady.
I will also, after this, I will take instructions just in case there is a difference
I
arising.
think that would be prudent, but I would be astonished if there is a problem.
Yes.
But it's
Understand.
healthy.
Yes.
Absolutely right. Yeah.
Um,
Okay. Well,
now
we
give-
proceed on the basis.
Yes.
Subject to the date. This is what he would have looked at if he'd chosen to go to.
Yes, but given the questions, can I just take you to page 25 of the bundle before we look at the policy? So page 25 of the same bundle, of the supplementary bundle, is
Shirley's witness statement.
yes, Mr. Shirley's witness statement. And if you look at paragraph 19 of his witness statement, page 29, and that's the reason I've said that this was the relevant policy, because Mr. Shirley says that it is. The claimant, he refers to Exhibit 6, the exhibit that I've just taken you to, and he says that, well, this is the policy as in time when the claimant made their applications.
Well, we have a mismatch in the
Right,
letter.
Oh yeah, there must be an accuracy in the witness statement, because it goes on to quote the date of 30th of November.
You see the point, Mr. Hope?
Yes, I do.
Yeah. Well, let's get to the bottom. Let's get to the bottom of it. But unless there's something wholly surprising, it's just I dotting and T crossing.
Yes.
Yeah. Thank you. Thank you. That's helpful.
Yes, I'm
Mr. Malik.
But can I ask you respectfully, just look at the first sentence of paragraph 19 in any event. The claimant received their letter confirming that they had been granted.
Something's wrong with the English.
Yes, but a short period of exceptional assurance,
Yes.
referred to as a short-term assurance. So the short-term assurance and exceptional assurance are not two different things. A short-term assurance is a subspecies of an exceptional assurance. This is what the Secretary of State's evidence is. And the claimant was granted exceptional assurance. The Secretary of State confirms that. but the subspecies of exceptional assurance that was granted was a short-term assurance.
Thank you. Let me just make a quick note of that.
Does the published policy, going back to 85, distinguish between the 10-week and the 2-week?
I'm not sure that it does, but I'll take you, of course, to the policy in a minute. So you've taken, of course, a note of the first sentence of paragraph 19. But if you read on that paragraph, Lord, with respect, so Mr. Shirley refers to Exhibit 6, the policy that I'm just about to take you to, and says that, well, that document set out what an individual would need to do if they wanted to remain in the UK. Mr. Shirley isn't saying that, well, that would tell you what you need to do if you need to leave the UK, but if they wanted to remain in the UK. So paragraph 19 is about the paragraph, about the guidance in question. Now, if you then look at Exhibit 6, page 85, so this is the coronavirus advice for UK visa applicants. If you go to page 86, you will see a heading, if you are in the UK. You're expected to take all reasonable steps to leave the UK where it's possible.
It doesn't state what the that's a very odd thing. Is this literally the first page of the policy? Mustn't it?
Yes, it is.
The unspoken premise of this, nobody has to take reasonable steps if they've got leave. So the unspoken premise is that you have your leave is about to expire.
Yes.
But it doesn't say that.
No, it actually says categorically that it also applies to overstayers.
Well,
Not.
When we get there, okay, but
Yes.
just reading this
Of course,
in context,
absolutely.
you might expect it to say something like, this advice is intended for UK visa applicants whose leave or a previous exceptional assurance is about to expire,
Absolutely.
but who say they still can't leave.
Absolutely. Now, yes. So, but the reason, the logical reason for that, Milady Milords, is that the Secretary of State knew well by that time that many individuals have already overstayed for various reasons arising from the adverse effect of pandemic. Businesses were closed, educational institutions were closed.
When you say that, obviously he knows it's a wicked world, but he shouldn't proceed on the assumption that lots of people have overstayed and ought to be given indulgence. There were machineries for them if they wanted to stay.
Yes.
So if they wanted to apply, and if they couldn't apply but also couldn't leave, they could apply for exceptional assurance and reapply if necessary.
Yes.
I don't think there's any reason to believe that the Secretary of State was intending to cope. You may take us some words later which
Yes.
show different.
Yes.
But the underlying assumption would be he wasn't attempting to provide for people who were overstaying. They shouldn't be here in the first place. They shouldn't be rewarded in the advance. Isn't that the logical starting point?
But when you look at the terms of the policy, in my
I was really just picking you up on your suggestion. The Secretary of State must have known,
yes.
or will have known, there were lots of people who'd overstayed, and I'm not sure that's the correct starting point at all.
well, that creates no difficulty for my submission. Yes.
In case you want to say anything about that.
Yeah. So
Just give me one moment while I just make a note.
yes. So page 86, so you'll see various links under the heading. If you are in the UK, if you look at the second last paragraph, if you intend to leave the UK to return to a country or territory, but have not been able to do so, and you have visa, leave, or exceptional assurance, which means that your leave has expired, but you have insurance that expires before 31st of October, you may request additional time to stay, known as exceptional assurance.
Okay, so that, in fact, that is in accordance with what I just put to you.
Yeah.
It's just rather odd to have it
So that's
after rather than the beginning.
So that's one purpose of this policy, which is to address people who have leave or where leave has expired, but they were given assurance.
Well, sorry, not who have expired, but is about to expire, because
Yes.
Yeah.
But I mean, of course, that is visa, leave, but then or exceptional assurance that expires. So not only leave, but of course also assurance.
Well, the problem here that we're concerned with is the case of someone who falls into neither of these.
Yes.
or none of those.
Absolutely. So no. I mean, of course, no dispute about that. But if this is all the policy had said, then I would have no case to argue. But the policy lists further categories where it would apply.
Yeah.
Now, if you go to the next page, page 87, you'll see that it tells us how to apply for exceptional assurance. If you look at the second last paragraph, during the period in which your request for exceptional assurance is pending, you will continue on the conditions as per your current, so when you have leave, or most recently expired visa.
But isn't that consistent with what I've just put to you? Imagine someone who has a visa expiring on, just take the dates from this document, 31st, who has a visa expiring on the 1st of October.
Yes.
And they make an application on the 1st of September.
Yes.
Or make a request, I should say. And suppose that hasn't been answered by the 1st of October, then the conditions, suppose it's granted before the 1st of October, then the conditions will be your current visa. Suppose it's granted after the 1st of October, it will be your most recently expired visa. It needn't necessarily refer to something that expired months ago.
No, but it also, in my respective submission, would apply to a person where, say, visa has expired on 1st of October 2022. That person has then been granted exceptional assurance, say until 1st of November 2022, and he makes an application while being an overstayer and while being on exceptional assurance for further exceptional assurance.
Yes, but he's still under the existing, he's not got a period of overstaying, in your example, in which he hasn't got some
assurance. Yes.
So that is a distinction from the
For the facts of, yes. So, yeah. So
you're thinking of the most recently expired visa could cover an applicant who's currently got an exceptional assurance that is about to expire
Yeah.
and applies for another one.
Yes.
But he's here.
It's different. Yeah.
lawfully.
Yes, but of course there are other provisions in the policy that are relevant. But the reason why I thought that I would make the point is to address the concern that the policy is simply about those who have leave to remain. It's not that. It's also about those who have exceptional assurance.
And of course, it also applies
To
to
exceptional
remain or exceptional assurance.
Yes.
But
So
the problem area is people like your client who have neither.
no exception. Yeah. Yes. But that's what. So the policy is not simply about those who have leave to remain. Now, if you then look at the next paragraph. Now, this so the paragraph that I've taken you concerns the position during at the time when the application is pending. But look at the last paragraph. If you are granted exceptional assurance, which in my submission this appellant was, it will act as a short-term protection against any adverse action or consequence after your leave has expired. If conditions allowed you to work, study, rent accommodation, you may continue to do so during the period of your exceptional assurance. It's not a grant of leave, but it is something fairly similar.
Can I just ask, because within taking us up to that, you made the submission that in fact he was granted exceptional assurance. If one looks at 223 of the main letter,
Yes.
the last paragraph, it says, as the reason for your request are not in line with the exceptional assurance policy, you issued you with a short-term assurance.
Yes. But I'll
Now, I understand you can say, well, the two are effectively the same.
yes.
So it's difficult, is it not, in the light of that, to say it is an exceptional assurance?
Yes. Lord, of course, take you to the letter once made my submissions on the policy.
We'll contain ourselves.
Yes, and I completely understand the point, and that is the reason I took you to the Secretary of State's evidence. She says that it is an exceptional assurance. So Miller and Friend, I doubt will make a submission that this appellant wasn't granted exceptional assurance. Now,
Heading of the letter is a bit of a bigger one.
yes,
The letter- heading of the letter is a bit
Yes.
of a- But can I just go back to the paragraph you've just taken?
Yes.
To, 87. It refers to being able to continue to work, study.
yes,
live in accommodation. Continue
yes.
may suggest you can do it at the moment, as in immediately before you make the application.
Well, yes, not necessarily with respect, because if you look at the first sentence, you'll see that it refers to leave having been expired. So of course, this will apply to those who have leave to remain, but also where leave has expired. Where leave has expired, but the conditions of the leave that had expired allowed a person to work, study, and rent accommodation.
That must mean have expired, as I put you, has expired since the making of the request. The whole thing is on the assumption that up to the making of the request, you still had leave. What your problem was, it was about to expire and you weren't able to go.
Yes, but yes, I mean, again, that causes, in my explanation, no difficulty for the argument that I'm seeking to make. But the effect of this paragraph is that if there is a grant of exceptional assurance, that grant acts as a short-term protection against any adverse action or consequences after your leave has expired.
And the next sentence really just spells out the consequences of that.
Yes.
If you had leave with conditions which allowed you to work, study, or rent accommodation, which most forms of leave would, unless they were very short term,
Yes.
you may continue to do so during the period of your acceptance.
Yes. But yeah, absolutely. So the effect of this paragraph is that grant of exceptional assurance, whether it's to a person who makes an application before expiry of the leave or after expiry of the leave, if there is a grant of exceptional assurance, then that acts as a short-term protection against adverse action or consequences.
It also apparently protection against the hostile environment
Yes.
policy, because that the prohibition on renting accommodation is part of that suite of.
Yes. Yes.
Doesn't dispense. You are, mind you, committing a criminal offence, but I suppose everyone just ignores that. It's
Yes.
not a grant of leave.
It's not a grant of leave.
It's a sort of administrative dispensation.
Yes, but the Secretary of State says that it's permitted stay in the UK. Permitted stay in the UK is the phrase that she uses to describe exceptional assurance. It's not a grant of leave.
Yeah.
It's permitted stay in the UK. Now, if you then go to the next page, page 88. Now, and this, in my submission, would resolve any doubts as to whether this was simply a pack-up concession. There is a heading as to what to do if you intend to stay in the UK. And if you look at the last paragraph at page 8, you are also able to apply for permission to stay, to remain in the UK, if you have been issued with an exceptional assurance. You must submit your application before the expiry of your exceptional assurance.
But that also is consistent with the much more limited interpretation I'm putting to you. But if you qualify for an exceptional assurance, you are treated as being in the same position as if the leave which you currently had at the time of your request had not expired. It doesn't necessarily mean that you are in a better position than you would normally be as an overstayer. I can't see how the policy could possibly be understood as being intended to give special privileges to someone who'd overstayed for months or even years, and then by the simple expedient of making a request for an exceptional assurance, which they couldn't possibly have got because they didn't qualify for it, suddenly has a new lease of life and can make a fresh application for leave to remain on a completely different basis. It would be extraordinary if that was the intention of the policy, wouldn't it?
So yes, so this policy applies only to those who overstayed during the pandemic. So if someone was an overstayer for years, the Secretary of State can legitimately refuse to grant exceptional assurance. She can say
also undermine the exceptional assurance policy has been in place for years, 2 years at the time of this application.
yes. So if you
That was the right thing to do if, because of the pandemic, you couldn't leave. If you
Yes.
don't do that, why should you get a prize for making an application which fails?
So a person who is an overstayer is an overstayer. If he makes an application for leave to remain, the Secretary of State will refuse the application under the rules on the basis that he's in breach of immigration law. He then makes an application for exceptional assurance. He says to the Secretary of State in the application that I have overstayed during the pandemic. I want to leave the country, or I want to make an application for leave to remain. I overstayed for X, Y, and Z reasons. My college was closed. My employer wasn't in business, and I became an overstayer. I should have applied for leave to remain, but I became an overstayer. Now, the Secretary of State grants that person exceptional assurance for 2 weeks or 10 weeks. Now, he was previously an overstayer, no doubt about it. But once the Secretary of State grants that person exceptional assurance, then that
I see how you
is
have to put it. I think we won't anticipate your point about having made full disclosure of the fact you're an overstayer in the application letter, which I don't think was done in this case. But you say that certainly if that is done, the intention of the policy is to allow them, as it were, as long as the overstaying was because of the pandemic, allow them to start afresh.
yes, to allow them to have a period of leave, a period of permitted stay, to either leave the country or to make an application for further leave to remain. Now that person has, of course, previously overstayed, historically overstayed. But there isn't a rule which says that previous overstaying is a disqualification. If the Secretary of State intends to have a rule which says that previous overstaying is a disqualification, she can have that rule, as she has similar rules in Part 9. But she hasn't formulated that rule. Now then, page 89, if you have overstayed your leave, this is again consistent with what Mr. Shirley has explained in the witness statement. This surely is about those who have overstayed, page 89 of the bundle. Now this paragraph is in two parts. It says, well, if you have overstayed, and that's the reason I submitted earlier that the Secretary of State knew that many people have actually overstayed, and the policy was addressing those people. If your visa has expired between January 2020 and August 2020, there will be no further immigration consequence if you don't make an application to regularize your stay during this period. So that is a categorical.
That's the so-called period 1, isn't it?
Period 1, yes. So that's period 1. So if you fall under period 1, you don't have to do anything. You don't have to apply for exceptional assurance. The Secretary of State will not treat you as an overstayer. But if you then look at the second part of that paragraph, however, if you have not applied to regularize your stay or submitted a request for exceptional assurance, you must make arrangements to leave the UK. And we know that you only apply for exceptional assurance if you don't fall within period 2. You don't fall within period 1. If you fall within period 1, then you don't apply for exceptional assurance at all.
You could say though that the only clear representation, if you like, for those who have overstayed, is that there won't be future problems if your overstaying was between the dates specified in 2020.
Yes, so if you overstayed between the dates specified, now whether or not you had exceptional assurance, there will be no consequence.
Yes, my point is that you could argue that that's the only clear representation in this.
Well, that is not how I would respectfully, of course, invite the court to read this. And of course, I note that, of course, Milady uses the phrase clear representation. Now, when it comes to the doctrine of legitimate expectation, one is looking at whether there is a clear representation. But that, as Mandalia shows us, is an entirely different concept in public law. So the question for the court is, what is the proper interpretation of this policy? So it isn't that, that I succeed only if the promise is clear. The court has to look at the policy as a whole and ascertain what the meaning of the policy was.
There were a number of different ways in which the case was put to as I understand it, you say you win because there's a clear representation in the letter, one, and also on a proper interpretation of the policy too.
Yes, and three, effectively, and I'll provide a summary to Malord in a minute. And the third is that we actually qualify under the rules. That's how I put the case at the upper tribunal. So I was instructed shortly before the hearing, and I pre-formulated the grounds and made these points. So this is the policy. Unless Miller and Friend is able to spot the point about 40-day grant and a 2-week grant, I've not been able to find that reference in the policy. You get that from the witness statement of Mr. Shirley. That isn't controversial. So that was the difference. So on proper construction, the effect of the policy is that if you are an overstayer and you are granted exceptional assurance, then you will not be treated as an overstayer during the period of exceptional assurance. That's all. You will be treated, of course, as a person who has previously overstayed, but you will not be treated as a person who has overstayed during the period of exceptional assurance. So this is the policy. If I may then address you on the letter. The authority on legitimate expectation, Lords are familiar with it. It's the judgment of the Supreme Court in Seerangan, tab 6 of the bundle, and there is a comprehensive summary of the relevant authorities on legitimate expectation in that judgment at page 91.
I know you're always meticulous about these things. I'm assuming it's in the Old Englands because it isn't in the official law reports. Is that right? Slightly surprising, but it does happen, I know.
That is.
Perhaps someone could just double check that.
I'll double check. Yes.
Yes, but simply it's only because in any judgment we have to refer to the those authorities. Yeah. Okay.
So page 91, you will see heading legitimate expectation, and under that heading you have a summary of the relevant principles, relevant authorities. The conclusion is at page 93, paragraph 62, where there is a clear, unambiguous undertaking, then the authority would not be allowed to depart from it. Now that concerns the letter alone, of course, not to the policy. Because when it comes to the policy, there's a freestanding right to be dealt with under the policy. But when looking at the letter, you'll see whether there was a clear promise that the appellant would not be treated as an overstayer during the period in question. No issue about previous overstaying. Now the letter is in the core bundle, page 223. And now, the reason why I said that Maleficent is not going to say that this wasn't an exceptional assurance, because it says at the outset that this is an exceptional assurance, confirmation of exceptional assurance. Mr. Shirley says that, well, this is exceptional assurance. There is a reference, a link to the policy, link to the guidance.
Incidentally, just I think it may help. What I've very quickly done while I was just studying this that I could cross-refer is I put paragraph numbers on each of the paragraphs. So, council wouldn't mind doing that. There should be paragraphs 1 to 8 on page 223 and 9 to 15 on page 224.
Yeah. Yes. Paragraph 5.
Yeah.
There are no reporting restrictions in place so far as India was concerned. And the exceptional assurance policy is a short-term protection, this paragraph 6, against any enforcement action for overstaying leave, visa, or previous exceptional assurance. In my submission, it's crystal clear that it is a protection in relation to overstaying as well.
Well, it is, but it's only that so far it is entirely consistent with it being for overstaying following the expiry of leave or previous exceptional assurance post request.
Yes, the Secretary of State, of course, is one who knows about the applicant. She granted leave to remain to the applicant. The Secretary of State knows that leave has expired.
Well, I don't know whether the Secretary of State, if they had looked at their records, would have known. No suggestion. Perhaps we, if you don't mind, we will just look at the application letter first.
Yes.
That's page 225.
Yes.
Sent only 2 days before. It gives a BRP number. I also, after all these years, know what that means, but I'm assuming that that is a Home Office reference number.
Yes.
So it would be possible for the Home Office, I accept, to check who this person is. But if they were just going on the letter, there is nothing to say that they are already an overstayer, and indeed, the second paragraph tends to suggest that but for that they're not yet an overstayer, but they need it to avoid becoming an overstayer.
Yes.
Pretty sure. By all means, tell me I'm wrong. But on reading through this earlier, just to see, I couldn't see any statement that, for example, something you were saying earlier, his leave expired several months ago, but he wasn't able to leave because of the pandemic.
Yes, if you look at the second paragraph, well, that, I mean, of course, I accept that the appellant does not say that his leave has expired on the date in question, but he talks about the impact of the pandemic. Everything collapsed, he said. Because of that, he was not able to complete his studies, explore the UK due to the restrictions, and he wasn't able to plan the life as he had planned.
Well, I dare say, but
Actually, middle of page 226.
Yes.
It's just below, between the two countries, due to our client's current immigration status, they can't employ him, which is a sort of cryptic reference.
And the next sentence, the COVID restrictions has affected the client's lawful status in the UK,
Ah,
so he's
thank
now
you.
classed
yes,
as an overstay.
I hadn't spotted that. That's an implicit statement
Yes.
that he's an overstayer, that his leave has expired, but he not quite clear why, but for some reason that's blamed on the COVID restrictions.
Yes. So if I before I take you, I mean, given that you have seen this letter now,
Yes, thank you.
now before I take you to the actual assurance letter, can I also ask you to look at the appellant's witness statement in the supplementary bundle?
Yes.
Take a note as to the relevant pages. It's supplementary bundle pages 19 to 24. Perhaps you need not to look at that statement now, but in that witness statement, he sort of explained this letter further as to how the pandemic affected his life.
Can you just give me the reference?
Yes, so supplementary bundle, page 19 of the supplementary bundle, 19 to 24. And you'll see that he says that, well, paragraph 1, that he came to the country to study, but he wasn't able to finish the study because of the pandemic. And he then explained how confusing things were.
So he does it 3 here, which is interesting, and I didn't apply under the assurance by the first deadline, 30th October. I'm not quite sure. I think that must be a mistake. But as I did not know about it then, I mean, the truth is, he should have applied for it before January, but there was such a policy at that time. It was existing all the way through, just with the dates moving.
Yes.
But anyway, I get the gist of that.
Yes.
Yes, okay. Well, we will,
That's,
of course.
that's the witness statement.
But I don't.
It's not, of course, relevant to the issue of law that you have to decide. but
Okay.
it
No,
gives
I
you
understand. That's
gives you the
helpful.
taste
We
of.
ought to read it, and we will.
So the Secretary of State knows, Miller and Friend will not say that the Secretary of State did not know that the appellant was an overstayer. She knew that the appellant was an overstayer.
Yeah.
She nevertheless granted exceptional assurance. This is page 223.
Well, can we just look, I take your points about the title, and that obviously creates a difficulty for the Secretary of State, but let's look at the substance of the letter.
Yes, so it's paragraph 7.
Yeah.
So the reasons for your request are not in line with exceptional assurance policy. But we have issued you a short-term assurance, which is an exceptional assurance, to allow you to schedule a.
It doesn't say it is. If this para were just read it by itself, I would have thought it was not an exceptional assurance. So it starts saying you can't have an exceptional assurance because your reasons for your request are not in line with the policy.
Yes.
However, we've issued you a short-term assurance, not described as an exceptional assurance, to allow you time to pack up, or, as you rightly say, to submit an application for leave if you intend to stay.
Yeah. So, the Secretary of State says in evidence that short-term assurance is exceptional assurance. This letter says at the outset that it is confirmation of exceptional assurance. And unless I've misunderstood Miller and Friend's position, Miller and Friend will not submit that this wasn't an exceptional assurance. If he makes that submission, I'll reply to that.
Yes.
But that was an exceptional assurance. And it wasn't a pack-up assurance for sure, because the Secretary of State says that it wasn't simply for you to pack up, but also to enable you to submit an application if you intend to stay.
But does that make a difference? It's to pack up, or because you may still be someone whose permission has, who had leave at the time of the request. The request has failed, but you may have you may have the chance to. There may be another basis on which you can apply.
Yeah. So if this wording had appeared at a policy, then that could be said that the policy is about applicants generally, but this is addressed specifically to the appellant.
Who has declared himself to be an overstayer.
Yes, and the Secretary of State knows that he is an overstayer.
I see that. Let us just assume the position is that this is Home Office incompetence and they have written an inappropriate letter.
Yeah.
The policy wasn't intended to cover someone
Yes.
in his position, but they haven't read his letter properly, or
Yes.
they
Yes.
just have a standard letter they send to everybody.
Yes.
Does that mean they're bound by it? If it's the letter but not the policy?
Yes. So it is, yes. So if, as the authority case law tells us, even if you have given an express assurance, in certain circumstances you can depart from it. But that's not the defense that the Secretary of State seeks to put forward. She's not saying that allow me to depart from this promise because of my incompetence or because I made an error. Now, if the Secretary of State had put forward that defense, then we would have addressed it. She's saying that, well, I've not given you a clear assurance that I will not treat you as an overstayer during the period in question. So the answer to my Lord's question is that isn't a point that the Secretary of State takes. And if she had taken the point, I would have argued that, well, it's not fair, appropriate to allow the Secretary of State to depart from this letter.
Can I just go back to clarify one thing? When we're looking at the letter, are you putting your case on the legitimate expectation?
Absolutely, yes. So letter.
Looking at the policy,
Yes.
you're looking at it from a sort of construction.
Absolutely.
In accordance with
Yes.
case law and templates.
Yes, yes, absolutely. Yeah. So this is paragraph 7. The Secretary of State says that if you intend to apply, you make an application. This is what the appellant actually did. If you look at page 24, next page, paragraph 10. And again, this will make it absolutely clear that this isn't a pack-up letter. You must now make plans to leave the UK or make a new application on or before the expiry of your current leave, but the leave has already expired, or exceptional assurance. Or exceptional assurance. So if your leave has already expired, then make a new application before the end of exceptional assurance.
This is just, though, is another way of throwing up the same point. You just suppose that he hadn't said that he was an overstayer, they hadn't appreciated that he was an overstayer, this would all be perfectly consistent with the policy, because the whole policy and this standard letter is on the assumption that someone has current leave or current exceptional assurance expiring at the date of the expiring after the date of the request, which is why they need cover in the future. And 10, against that background, 11 would be completely unexceptionable and wouldn't help you at all. Your point, however, is well, the first point is actually the policy on its true construction does include people who haven't got permission at all.
Yes.
But even if you're wrong about that, this letter was written to someone who had declared that they were overstayers, and effectively he was entitled to rely on it.
Yes. Yes. If
I really just point I'm making is 11. I think all these points you're now going to go. I won't stop you making them, but they all come back to the same point.
yes, but of course, this isn't a policy, and this is a letter addressed to the appellant specifically. Now, if the letter was issued written in error, then the Secretary of State can plead that, well, I made a mistake. This isn't a letter that I should have issued to the appellant.
That's never been the case.
And Mr. Shirley tells us that, well, this is the letter that was issued, and the premise is that it was issued correctly because the appellant falls under the policy.
Yeah.
In that sense, Mr. Shirley says, well, look at the policy, paragraph 6 of his witness statement. That's the exhibit. The appellant, the claimant was issued a short-term assurance accordingly. And then if you look at the next line, paragraph 10, you may also be regarded as an overstayer, which could be detrimental to any future applications you wish to make. So if you don't make an application before expiry of your acceptance assurance, you'll then be regarded as an overstayer. Now, if you were in any doubt that the Secretary of State knew about the expiry date and the fact that the appellant was an overstayer, then that should resolve by looking at paragraph 11, where the Secretary of State refers to the immigration records. Your immigration record has been updated. So she knows that he is an overstayer, but she has updated the record to say that assurance has been given and you will remain on the same terms and conditions as your previous grant of leave. Previous grant of leave. The leave that she knows has expired. If conditions of your previous grant that has expired allowed you to work, that will continue until the expiry of your assurance. This isn't an extension of leave, but quite similar. So he was previously an overstayer, but during the period in question, he would not be treated as an overstayer. In paragraph 12, during this time, that is until 30th of November 2012, you will not be regarded as an overstayer or suffer any detriment in future applications. You must make plans to leave the UK prior to the date of your current leave or assurance expires. If you do not do that, you may then be classed as an overstayer. This, with respect, is crystal clear. The Secretary of State made a promise that she would not treat the appellant as an overstayer between 16th of November 2022 and 30th of November 2022. Now, he makes an application for leave to remain before expiry of this assurance in accordance with what he was advised, and the Secretary of State refused it. Can I just finally take you to the decisions now and show you what the Secretary of State did? So the Secretary of State's decision is at page 165 of the core bundle. The decision of 19th of December 2020. So page 166, you'll see heading reasons for decision. If you look at the third paragraph, from 30th of January 2022, you have overstayed. CV assurance cannot be used to submit an in-time application during the period of assurance if the previous leave and conditions have expired. It was commissioned to stay for temporary protection against enforcement and for you to travel back to your home country, but you choose not to return. But surely this is not what the letter said. The letter did not say that I'm granting you temporary admission, granting you assurance to enable you to leave the country. The letter said I'm granting you assurance so that you leave the country or make an application before expiry of the assurance.
Well, can I just ask you this question? I mean, more sort of the generality of it, where you've got someone who says one thing in one letter and then pretty shortly afterwards says another thing. Is it right to look at the detriment that the applicant has suffered, rather than, because a reasonable person would say, well, I frankly haven't got a clue what they're saying. They told me the policy meant one thing in one letter, and then 2 weeks later they sent another. They're hopeless, and then you look really at the general question of fairness, or is that wrong in public law?
No, that's wrong in my submission in public law. Finnegan is the authority on that. So detriment isn't relevant. But I will not, I mean, unless you want me to make submissions on that, because detriment isn't a point that the Secretary of State has taken.
Let's see how Mr. Hoban puts it, and you may have to deal with it.
Yes, so he's not saying that, well, allow us to depart from the assurance because it caused no detriment to the appellant. It did, I mean, of course, but that isn't a point that is taken. So the point that is made at page 166 in the paragraph that I've shown you is with respect to misreading of the letter that I've shown you. You then see the relevant immigration rules. Paragraph 39E does not apply here. It has no application. You'll then see a reference to page 167, a reference to paragraph 9.8.3. You'll see that allows the Secretary of State to refuse an application for permission if a person has previously failed to comply with the condition of your permission, but the Secretary of State accepted that it wasn't open to her to refuse an application under that basis. The appellant breached no conditions of his leave. So that point was dropped. You'll then see a reference to paragraph SW 2.2, which says that the applicant must not be in breach of the immigration law, but that is about the current breach as opposed to historic breaches. There isn't a rule which says that previous disqualification
It's a bit of a muddle, isn't it? Because if they're only going to rely on 9.8.3, they should only have referred to SW 2.1.
Yes, but it's common ground that 9.8.3 does not apply.
Right. I mean, forget whether it's right or wrong. It's just an incompetently
of course
put together letter.
Yes. but then there is a reference to SW 2.2, but really no explanation as to what's going on here. That rule is about present breaches of immigration law, present overstaying, not historic overstaying, and there is no historic overstaying is not disqualification. So so three points that I make just to give you a summary. If the court is persuaded by the submissions, any of the submissions that I've made, there are three routes to grant relief to the appellant. The first is to read down the immigration rules, to construe the phrase breach of immigration law so that it entails living in the UK after expiry of leave or after expiry of permitted stay. So in other words, a person who has been granted permitted stay and exceptional assurance is not a person who is in breach of immigration law, although he's sort of technically an overstayer. And Pokrial and Aridoyan is the authority that allows you to read the immigration rules in line with the policy and letter. The second way...
That's only if they're ambiguous.
Yes. Immigration law, I've taken you to the definitions.
Yeah.
But that's one way to look at it. The other way is to, if the court is with me on construction of the policy, to say, and that's how I put my case, that there is, the appellant has a public law right to be dealt with in accordance with the policy.
If you win on that, you don't really need the first one. The first
We
one
don't.
you don't really need, do you? Effectively, you've got to. It all turns on the policy and the letter. Looking at the policy first. If the policy makes it clear that you won't rely on the letter of the rules in certain circumstances, you could treat it as you could try and read down the rules, but you don't really need to. You just say rely on the policy.
Yeah. Yes. Yes. And well, and third way is classic legitimate expectation. The letter says what it says. And for the purposes of the rules, the reason why I make the submission is that entirely accept that there's nothing in the policy or in the letter that says that previous overstaying will be disregarded, or the appellant would be treated as an overstayer, will not be treated as an overstayer from the date on which his leave expired. The only assurance was that he would not be treated as an overstayer during the period in question. He made his application during the period in question, and he was not, in my submission, in breach of the immigration law when the Secretary of State himself says that assurance is permitted stay in the UK. Now, finally, the upper tribunal's decision, page 43 of the bundle. Can I just take you straight to what, in my respective submission, is the offending paragraph, the paragraph that I seek to challenge directly. It is page 63 of the bundle, paragraph 43. The judge says that it's not enough for the applicant to say that the effect of the assurance letter was that he would not be treated as an overstayer during the period of assurance. For the applicant to succeed in this claim, he must establish that assurance letter amounted to a clear, unambiguous undertaking that his previous overstaying would be disregarded. Well, I'm not making that submission. I did not make that submission at the upper tribunal. I accept that the letter said absolutely nothing about previous overstaying. The letter is about present overstaying, and the rules, there's nothing in the rules about historic or previous overstaying, and previous overstaying is not a disqualification. So this analysis, in my respective submission, is based on a misunderstanding as to a misconstruction or as to the relevant rule, paragraph SW 2.2. The judge in my submission took the view that that rule allowed applications to be refused because of previous overstaying. And then you'll see that the judge makes reference to the disregard provisions, and that's not the point. So that paragraph reflects an error of law. And finally, paragraph 47. This is where you'll see a conclusion.
Sorry, just before we leave 43, the last sentence, the judge does talk about for overstaying and not past overstaying. What do you say about that last sentence?
Last sentence of paragraph 43.
Yeah.
So beyond 31st of August, neither the policy nor the immigration rules provided an automatic extension of leave or for overstaying to be disregarded.
Yeah.
Now the submission is that the policy and the letter did say that overstaying would be disregarded during the period in question, not the entire overstaying, but the overstaying during the period in question. Of course, it's not an automatic extension of leave to remain, but that's how I put my case. So paragraph 47, this is where the judge concludes that the appellant falls for refusal under paragraph SW 2.2. The policy and the assurance did not cure his previous immigration status. I accept that the policy and assurance did not cure previous immigration status, previous overstaying. But as I sought to demonstrate, previous overstaying is not a disqualification. Had there been a rule,
That's because of the concession made about 2.1.
yes.
So that really is at the heart. I wouldn't mind just seeing where that was withdrawn, and does the judge record that it was withdrawn? Is it 30?
Yes.
The Secretary of State now concedes that the correct basis for a legal refusal is not SW 2.1 but SW 2.2.
Yes.
She doesn't say the reason for the concession.
25B.
Sorry?
25B.
It also says it, but just doesn't say the
So if
reason.
you look at paragraph
Yes,
25,
I see. Thank you.
yes.
Oh, thank you. Yes.
So these are my reformulated grounds, and sorry, what happened following the reformulated grounds? Not if you.
Requires a bit more careful thought than I've given it.
Yes. If you wish to see more about that, can I just show you just another document. Yes, page 90 of the bundle. This is my skeleton argument that was before the upper tribunal. The skeleton on the basis of which the Secretary of State made the concession. And
Okay, let me just. Paragraph 20.
page 90, paragraphs 21, 22, and 23.
Has the concession.
Thank you.
Well, 22 is obviously a nonsense. What overstaying isn't a breach of conditions.
No. And the Secretary of State initially argued that.
The Secretary, I'm sure, conceded that.
Yes.
Where do I find the concession
It's
about the point made in 23?
Yes, it's page 82. This is the Secretary of State's skeleton argument.
The concession was only
It's
on
rather
22.
It's obviously conceding the conditions point,
Yes.
which is obviously it may actually be a breach of conditions, but that wasn't the reason. So we can assume he wasn't for present purposes.
Yes.
So obviously, right to concede that. That's not a reason for conceding the whole of SW 2.1 because that. What about overstaying?
Now, SW
My big mistake.
2.1 simply refers to Part 9 of the rules.
Oh, I see.
And there is nothing in Part 9 of the immigration rules about about there being a disqualification because of previous overstaying.
Hang on 1 second, that's correct, all right. But
Yeah. So tab 3 of the authorities bundle, page 44.
Yes, I see. Your point, this is the point you made earlier, and I didn't fully take it in. But 9.8.1, which is about previous breaches, is related to entry clearance
Yeah.
or permission to enter, and that's not what we're concerned with here.
And the submission that I made was that if the Secretary of State wanted to have a rule that allows that to the effect that previous overstaying would be a disqualification for the purposes of this sort of application, then this is the language that she would have used.
The decision letter also only relied on 9.8.
But hang on. Well, but if we look at 9.8.3, which is the one dealing with application for permission to stay, it may be refused where a person has previously failed to comply with the conditions of their permission.
Yes.
Oh, I see.
Unless permission has been granted.
So is there no right to refuse an application for permission to stay on the basis of previous
No.
overstaying?
No. So
That surprises me, but if you say, I mean, I know that.
the policy, as I understand, is that if you have overstayed, but the Secretary of State has granted you leave to remain,
Since by definition, this will only arise in a case where you now have leave to remain, because otherwise they get you on the
Yes.
current position.
yes,
So there is no right to refuse under Part 9, to refuse permission to stay or leave to remain, because I'm old-fashioned, under Part 9 on the basis of previous, so-called bookend, what we call bookended overstaying in
yes, book-ended overstay, yes.
Well, not even subject to a proviso that it's all right if the Secretary, that's only if the Secretary of State knew.
No, unless I've missed something completely.
What about 9.8.4? Today.
It's only 9.8.1 and 2.
So that concerns entry clearance.
Well, Mr. Hoban can address us on this. Because 276B does
That's about
allow, it starts by allowing refusal of indefinite leave to remain on the basis of previous breach of laws, which includes overstaying.
yes,
But then it's qualified.
yes,
But subject to the qualification, that is a reason for refusing the ILR.
yes. So
So
if
that's only 276B, is it? It's
That-
not
that-
Part 9.
no, that's the point. That's the reason I took you through the rules. That if the that's the reason I took you to Mahad at the outset, asked you to compare and contrast the language of the rules.
Yeah.
So the Secretary of State could have SW 2.3 saying that, well, your application will be refused if you have previously overstayed. But there isn't a rule that allows the Secretary of State to refuse on the grounds of previous overstaying. The appellant, when he made his application,
Okay.
was here on a permitted stay, and that's how I
Yeah,
put
well,
the case.
Mr. Hoban has, I'm not sure quite how it fits into the actual arguments, I'm not sure, but it's important background. At the moment I'm surprised, but I agree, the passages we've looked at, you seem to be right.
So unless I can assist you any further, I think these are my suggestions.
Sorry, just on 9.8.4,
Yes.
that deals with, is that all restricted to 9.8.1 and 9.8.2?
That's yes, because it
So
says
it's not a separate freestanding.
No.
Yeah.
yes, there is another provision which talks about a person frustrating the scheme of the immigration rules in
yeah.
a significant manner, but that's not this case.
9.8.2C.
Yeah.
Thank you.
So the Secretary of State refused the application because she treated the appellant as an overstayer when he made his application on 29th of November 2022, despite telling him that on that date he would not be treated as an overstayer. And previous overstaying is not a disqualification under the rules.
Right,
So unless I can assist you any further, these are my submissions.
thank you very much indeed, Mr. Malik. Yes, Mr. Hoban.
As you will have noted from the skeleton argument, our position is that this is in essence a case about legitimate expectation only, and not about the interpretation of the rules, or indeed, as we'll come to, strictly about the interpretation of the policy.
Yes, you'll need to make that good, but
Yes.
we're going to.
Yes. If we've gone through the background, and we'll come back to the terms of the actual letter itself. So I will repeat that. And touched upon the decision below. It's probably helpful to go directly to the rules and what we say about SW 2.2. It's accepted that on its face it's about current.
Can we just be clear? I'm sure it is clear, but this case was argued below on the basis of SW 2.2 only.
Yes.
And therefore is defended on that basis.
Yes. SW 2.1 doesn't apply for the reasons already identified by Mr. Mavick. It's agreed a breach of conditions wasn't relied upon in the decision. The decision letter itself, which we looked at 167, refers to 9.8.3 specifically. That's 167 of the core bundle.
Yes, right.
And then refers to 2.1 and 2.2. So that's the scope of the refusal. And I accept what Mr. Malik says, that even if it had referred to 9.8.1 and 2, that refers to permission to enter. I think the answer to your lordship's hypothetical about, well, what happens if a leave had been granted for a previous period in error? Well, that's likely to be if it's because there was a misunderstanding as to someone having previously overstayed. It's likely that the person would have misled the Secretary of State in some way on their application form. But if the Secretary of State has granted leave with their eyes wide open, I accept that the current policy of the Secretary of State, subject to certain caveats, is that, well, we'll disregard periods of overstaying prior to that eyes wide open grant of leave, so it doesn't come back to bite someone again.
So, right, you were saying this case was and is argued on the basis of SW 2.2 only, and you say that you accept that on its face, SW 2.2.A refers only to current breach.
Current breach of immigration laws, in this case overstaying.
So on its face suggests you're about to suggest that's not the rule.
No, yes, it is. That's what it refers to. There is a conceptual issue here, though, which we'll come to, which is really about the assurance, not about the rules. But I'll come to it. Yes. So I accept that the paragraph is about current overstaying.
Okay. So the question for us, therefore, or rather for the Secretary of State, was in the light of the effect of the assurance, was he overstaying at the moment on the 29th of November when he made his application? Or was he entitled to be
Treated as.
could he properly be treated as overstaying?
That's
Because that's the issue in the appeal.
Yes. So we come then to the we go to the nature of the letter, the promise, before we come to the policy, because in my submission, this is not an exceptional assurance within the terms of the policy, the published policy. There's obviously.
Hang on 1 second, because someone write that. Okay, yes, down to the letter, yeah.
It's not an exceptional assurance within the terms of the published policy, and the letter makes that crystal clear.
That's para 7, isn't it?
In para 7, yes. What it is a short-term assurance, which is something made given pursuant to an unpublished
Yes, how do
policy.
you fit that with the heading involved?
Well, well, the answer is it's a standard form letter, and it of course has, in the Secretary of State's view, the same effect as she intended the policy to come. But well, exactly. So we say it all comes down to what is objectively said in this letter. My point is this: that my primary submission is that it's not open to the appellant to say, look, I'm entitled, whatever the letter says, I'm entitled to what the policy would give me. I've been given an exceptional assurance. Let's look at the policy I fall within it.
Well, that's only part of what he said. Let's just, you quite rightly said, let's deal with the letter separately. So ignore
Yes.
the policy for a moment. Let's just look at what the letter says.
Yes.
The letter says that it's the confirmation of an acceptable assurance. What do you say about that? All right, more accurately, the heading of the letter is the
Yes.
phrase confirmation of acceptable assurance.
Yes, no, I accept that, and of course it has. What is then given below is something that looks very like an acceptance assurance, but is different, and it's expressly stated not to be something within the published policy. That's the point.
All right. Let us be frank. You agree? Do you agree? Is this your position that the phrase confirmation of acceptable assurance, if read by itself, is misleading and wrong because acceptable assurance is not? But you've got to read the letter as a whole. The text is more important than the heading.
Yes, I would accept. I would certainly accept it brings a degree of ambiguity, and as there are other aspects of this letter that are ambiguous, and I accept not as clear as they might have been.
Ambiguity might be misselling it.
Indeed.
Hang on 1 second. So then you say it is crystal clear from para 7.
Yes.
And I suppose you read 5, 6 and 7.
Indeed, 5, 6 and 7.
So 6 says the policy is about travel restrictions caused by the pandemic.
Precisely.
7 says
You don't fall within it. So what is then given is this short-term assurance by reference to the principles behind the actual published policy, which is the exceptional assurance policy.
Hang on 1 second. So the short-term assurance itself is an unpublished policy.
Yes.
There's an unpublished policy.
It is, yes.
If you refuse an exceptional assurance, you should nevertheless give what you're calling a short-term.
A short-term assurance, yes.
Not an ideal phrase, short-term assurance, because exceptional assurance is itself described as a short-term assurance.
Indeed, yeah, it creates I accept it's it creates an ambiguity.
In that sense.
Yes. But of course, this assurance is given against the background of the exceptional assurance policy, and as you can see, it's effectively adopted a pro forma letter with some very significant overlap.
Hang on.
Well, the recipients of
No. But the thrust of my initial point is this: that it's not open to the bearing in mind the clarity with which it is said you don't fall within the policy, and this is something different, albeit I accept the terminology is confusing.
It's something different, but Mr. Malik says it's not something different. There are 2 species of acceptable policies. One granted to people who comply with the policy and get 10 weeks as it happens. and one granted to people who've applied, but don't comply with it, who only get 2 weeks. They're both exceptional assurances. The difference is that just how long they are.
Well, in one sense, that's correct. The primary position is that in terms of the effect of what assurance is given, it is always the actual assurance, the substance of the assurance is of similar effect, but for a different period. That's what we say, the substance of the assurances.
So the substance of the short term.
The substance of the short-term assurance, we say, would be of similar effect to the kind of assurance that you would get under the exceptional assurance
in the sense that
policy.
In the sense that you can go on working and you won't be 2 weeks, you will be shut out anyway, actually, but still, in principle, you can't have any enforcement action taken against you for those 2
Yes,
weeks.
in principle,
And
no
that,
enforcement.
almost most importantly, it won't be a black mark if you leave and apply again.
It won't be a black mark if you leave and apply again, and during that particular, as we'll come to, only during that period, it won't be treated as if you are overstaying. A bit like 39E.
What does that mean in practice? That means no enforcement action.
Well, let me give one example where that might be of a particular assistance to somebody. Let us say that you. My position, as we'll come to, is that the exceptional assurance policy is, as your Lord identified, targeted towards those who are making this request when they still have leave. That's what the target of the policy is. Yes. But let's say we have somebody who has a let's say we have somebody who actually makes their request after the expiry of their leave, like this appellant, but within a very short period of the expiry of their leave. So within the 39E disregard period, for example. They then say, I want to apply for an exceptional assurance, but like this appellant, I'll refuse and only get a short-term assurance. They then, during the period of that short-term assurance, make a further application for leave to remain. They may be a beneficiary, then, of what is in effect an extension of the 39E disregard period. Do you follow? So the 39E, this is just an example of someone who might be a beneficiary of the overstay position.
It's overcomplicated. It's perfectly obvious that the person who gets the 2-week instead still gets some benefit from it.
Yes.
A largely academic, but not completely academic, exemption from enforcement measures.
Yes.
No black mark if they then do leave and apply from abroad.
Yes.
In circumstances where if they were an overstayer, they'd be refused.
Yes.
Their landlord is required to chuck them out, their employer is required to sack them,
Yes.
and so on.
Yes.
So, and there may be other, but
Yes.
it really doesn't matter. There are advantages, of course.
There are advantages. There are advantages. So I was wondering if you were thinking there was needed a particular explanation for the word overstayer and the period. So that's the purpose of the letter. Therefore, is simply to give you this outside of the policy assurance.
Doesn't make that clear, does it?
Well, it says it does say it's outside of the policy as we've come to, and then we come to what is the assurance actually given, and you do have to read the letter as a whole, but focusing on the particular paragraph, it says during this time you will not be regarded as an overstayer. This is paragraph 13 by my count. During this time, you will not be regarded as an overstayer or suffer any detriment in any future applications However, you must make plans to leave the UK prior to the date that your current leave or assurance expires. If you do not leave on or before this date, you may be classed as an overstayer. It's notable actually in that paragraph, the substantive paragraph, which gives the promise, it doesn't make any mention of making a further application at all.
What about paragraph 12? Which
Do you mean 11?
does say, I mean, if we're looking to see what is granted, which
Yes.
I entirely provisionally is the right thing to do, you will remain on the same terms and conditions as your previous grant of leave.
Yes. Well,
So, I mean, that seems to be a perfectly clear statement.
yes.
You previously had leave as a student. You are now to be treated as having leave as a student. Is that a fair analysis or not?
That is it's a fair analysis of conditions. You're to be treated in terms of conditions, specifically of work, study, and rent of accommodation. What it doesn't say is you are to be treated for the purposes of making an application. Indeed, it specifically says, please note, this is not an extension of your leave.
That's true, but it also says that you will not be treated as an overstayer. C13.
Indeed, not be regarded as an overstay or suffer. But it says very specifically, during this time, you will not be regarded as an overstay. During this time. Now, I understand that creates
Its application during this time.
well, indeed. But what we submit is when it's saying during this time, it means specifically during this period. That period will not be treated as an overstay. Not, but when you make an application, and it is considered by the Secretary of State, you will be treated as falling within the immigration rules.
So that period isn't treated as a period of overstaying.
Precisely, which comes back to maybe we'll try. I will try and explain better my point about 39E. It effectively could mean, for example, it's an extension of the disregard period. So, if in a world where someone's might be refused leave because they've overstayed for longer than the 39E period.
That's the 14 days.
The 14 days, exactly. You could have an extra period. So if you had made this request within 14 days, got your exceptional assurance, and then made an application, 28 days, say, after your leave expired, you would still be treated as if you fell within 39E because the Secretary of State would disregard that period of overstaying. That's the point of this assurance. What it's not going so far as to say, particularly looked at in context, is that we're going to change the meaning of the immigration rules. We're going to give you a right to make an application for leave outside of the immigration rules. That effectively this would be an amnesty, as your lordships have already identified, for people who are overstaying. It would be quite an extraordinary position to take. So please come out. Anybody can come out of the woodwork if your leave has ended after COVID, and we'll give you. If you apply for an exceptional assurance, we'll disregard everything. If it had been intended, and if there was a clear and unambiguous intention that that's what was being offered in this letter, in my submission, it would have said so. the terminology in terms of detriment for future applications is important as well. It's saying during this time you will not be regarded as an overstayer or suffer detriment in any future applications. It doesn't say you will not be regarded as an overstayer in future applications.
Well, hang on, does the word in any future applications qualify only any detriment, or does it also qualify not be regarded as an overstayer? So not be regarded as an overstayer in any future applications.
It says suffer any detriment in any future application. The overstayer part is separate, but it's in any case, it's even if it applied to both provisions.
I wonder about that actually.
Even if it
The previous paragraph 12 seems to be dealing with the consequences of being an overstayer during your continuing presence. Apart from the interrupting words during this time, tends to be more about, and now we deal with the question of what will happen if you make a future application.
Well, if that's the position, it's very clear that it says during this time, and in my submission that is it doesn't say that you will not be treated
I
in
think
general.
treating words during time as legal in effect in respect of this 14-day period.
Yes.
Because that would make more sense when you cross-refer it to suffer detriment in future applications, because it could be any future applications.
Yes. Yes.
Including much later
Yes.
applications,
Indeed.
not just during the winter.
Indeed, it could be much later applications. And so,
are you accepting my lady's suggestion that your submission amounts to saying that during this time, in context, means in respect of this period?
yes. It's the point about that 14 days not counting towards a period of overstaying, but only that 14 days. Which brings us to what the judge below said in relation to this point. Now, my learned friend has obviously highlighted the use of the word previous overstaying, and I accept that perhaps that use might engender confusion in a world where there was a distinction between SW 2.1 and SW 2.2, the previous and current overstaying, but it has to be looked at in context. She's talking about my submission previous to the application, and it's fully understood, given the discussion you've already had, the concession that's already been had about 2.1.
So what did you?
Well, as I flagged up in my skeleton argument at 27, she repeats 27 of the judgment, page 59. This is recording Mr. Malik's submissions on the effect of the immigration rules. So she's recording, and indeed underlines the word previously over the page. So she's understood. She's grappled with that argument, and doesn't anywhere say that in principle that interpretation of the rules is wrong.
You made the point that she understands that it's not about previous overstaying. But
Yes.
what then did you mean by referring to previous overstaying in paragraph 3?
When in my submission, it's about being previous to the application. When she says any previous overstaying by the applicant would be disregarded in future applications, i.e. previous to the application, that's what she's talking about in the normal sense of the word.
So it's not previous, it's really current overstaying beginning prior to the application.
Indeed, yes.
Another way of putting this is that the secretary thinks he was always an overstayer
Yes,
for the purposes of applications.
yes. He was always a...
And the state, where it isn't straightforward because the statement to this is not.
No, it's not. It's there are various ways in which the decision letter in particular, and at this point, even the judgment below, I accept, could be put differently and better. But as you say, it's conceptually difficult because what you have is a policy where the Secretary of State is trying to say, well, I'm going to give you this leeway, but I'm not giving you leave, and I'm not altering the immigration rules. And what does that mean across a whole range of concepts? And in the context, as we'll come to in a second, where the policy, as your lordships identified, is really focused on people who are making this request before their leave expires.
Well, let's come to this. So is the letter. The letter is a standard letter, which clearly has that as its assumption, I would suggest. But as Mr. Alec points out, the Secretary of State knew that he was an overstayer. The application was made with full disclosure of that. They could have checked if they wanted
Yes.
to receive. So why were they sending a letter to an overstayer who should have been sent a different letter saying you can't make an application under the EA policy because you're not the kind of person for whom the EA policy is designed? Not because India is a closed country, but because you're already an overstayer, so you can't benefit.
Well, that would have been an option to say you're already an overstayer, but they still wanted at this time, for whatever reason, the Secretary of State still wished to give people in this circumstance a short-term period to leave, perhaps recognising that there wasn't straightforward.
The Secretary of State has to be accepted to be intending to give a short-term period to leave to overstayers.
Yes, we're not suggesting it was overlooked, but there was a.
Let me just write this down.
Yes, it's not suggested it was overlooked that he was an overstayer. That's not the basis of our saying this is.
Sorry to interrupt. Can I just make sure I got it right? The Secretary of State was intending to give a short period of leave or to leave.
Sorry, a short period of not leave, a short period of assurance, notwithstanding that he was an overstayer. So he's intending to give this appellant a period of assurance.
Why? What an odd thing to do. Why is he entitled to such a period?
Well, he's not entitled to such a period under the policy.
Why is it the Secretary of State's policy to give?
I don't have the details of.
Of course, I'm not really asking.
Yeah.
I'm just trying to ask why it makes sense.
Why might it make sense? Well, it may make sense in a world where quarantine, obviously in the world of COVID, quarantines are going backwards and forwards, and the Secretary of State may understand practically the difficulties that may arise if she takes a hard line on these matters in each and every case. Litigation, for example.
So it's just continuing
But
to
those are
Some leeway
I
during COVID.
I speculate, but that's the basis for which this decision letter is obviously written by reference to the assurance.
Subjective speculation. I'm trying to make sense of the situation.
Well, I don't know.
To me, it doesn't make sense that by making an application for exceptional assurance in circumstances where you don't qualify for one, and where probably, I'm not saying in this particular case, it should be obvious you didn't, but you could do it quite cynically. I'm not saying that in this case, quite cynically apply for exceptional assurance, which you know you can't get because actually everyone knows the year is open.
Yes.
You would nevertheless then suddenly get given a little patch of 2 weeks when you're not an overstayer, even though you've been an overstayer for the previous 9 months. How does that make sense?
Well, I can't say why a policy decision was made, or precisely what the policy decision that was made. All I say is on the facts of this case, this is the assurance given to this appellant. And as you've already identified, he said in his letter that he was an overstayer, and Secretary of State doesn't rely upon her having made a mistake as to that fact. But it does highlight that one of the key elements here is that this is a grant, an assurance outside of the policy. So it's why I say that whatever the policy says, whatever your interpretation of the policy document, the starting point is, what does this letter say? Now, the policy document does still provide background, because what would be extraordinary is if, notwithstanding the fact the person doesn't fall within the exceptional assurance policy, they got a short-term assurance that was even better than somebody who was entitled to exceptional assurance.
Can I just ask?
Yes.
This just before. Right. Are you saying that at the time he is given this concession for whatever reason, and however you describe it, he is then currently in breach of immigration laws?
Yes. There's a question.
For the purposes of making, as I understand it, you're saying that he is for the purposes of making applications.
Well, he is full stop, but he is. The question is, he may not be treated as such for certain purposes.
For example,
The right
suggestion that he can carry on
working, studying,
Yeah.
renting accommodation won't be subject to enforcement action.
Yes.
So why does it then refer to the possibility of him making an application during this period? If
Well, there's two answers to that. One is that obviously in terms of the operative paragraph doesn't actually refer to that at all. The operative paragraph, where he's given his assurance about overstaying, doesn't actually refer to making an alternative application.
that's paragraph 7,
But-
but you can't read that by itself, because there's a whole lot of other paragraphs which then flesh out or spell out what the consequences are of the grant that's been given.
Yes. Well, indeed. But if he made the second point is that if he has it's of course open to him to make a further application, and that will potentially have a material impact on what immigration enforcement or consequences he may that may follow, depending upon the type of application he makes, etc.
Is there any kind of application which a person could make while a current overstayer?
That would entitle them to equivalent of this assurance?
No,
not that I can think.
I'm not asking that.
Well, he could make.
You have a letter which says you've got this kind of assurance, and one of the things you can do during the period granted by this assurance is you can make a further application.
Yes.
Now, it's a very odd thing to say if that person is an overstayer, because there's no application you could make while you were an overstayer that had any prospect of success, because
You could make a human rights.
You make a human rights application. Make human right. Yes, and it would be correct to say that it wouldn't have the effect of 3C. It wouldn't give you the right to work and study or have accommodation, but it might, for example, prevent any removal action. Or alternatively, if it was an asylum claim, it might give you the right to be given accommodation. It might do all sorts of things.
so hang on, but I just
help
want to
you.
look at these 12 and 13
Yes.
points just before we rise. You say that this isn't a mistake. The Secretary deliberately intended to give to overstayers.
To this overstayer, anyway.
All right.
To this overstayer. I don't wish to overstate it, because although I'm aware there are other claims behind it, I'm not entirely sure I'm au fait with the details of each and every one of those claims.
All right, but okay, to give to this overstayer, a short-term assurance in accordance with paragraph 7. What does a short-term assurance mean? And really, what it means is picked up at 11. It means that you must make plans to leave the UK or make a new application.
The terms of the assurance are, 11 is telling you what you should do. 13 is telling you what the 12 and 13 are telling you what the assurance is.
Okay. It says your immigration record has been updated to reflect this. So if we were to look at his immigration record, we would find, we don't know,
Short-term assurance, there'll be something there.
and you will remain on the same terms and conditions as your previous grant of leave. So that means, because they knew he was an overstayer, it must
Yes.
be the one that expired 9 months previously.
It must mean. It must mean that. Yeah.
So that means that he can go on working, studying and renting accommodation, because those are all things he was entitled to do.
Yes, I mean.
A student, but he had a right to
Yes.
work, whatever the
Yes.
quoted hours were. Okay, so far so good.
Yes.
It's not then you made the point this isn't extension of leave, it's some different creature. Then during this time you will not be regarded as an overstayer. In any future you will, then it also says, let's assume that you're right, as my lady put to you, that it say in respect of this period you will not be regarded as an overstayer or suffer any detriment in future applications. Right, so you say that's fine, but his problem is not in respect of this period. His problem is that he is still in breach of immigration law by being an overstayer.
Yes.
Why, since he makes the application on the 29th, isn't that good enough for his purpose? Because the overstaying can be current.
No, in the context of, as I say, in the context of the lesser as a whole, because it says nothing about assisting him in not being treated, in how his application will be then treated beyond that period. That's what we say. When we come to the other point to make is that when we come to the policy, as we've already flagged up, even if it is by reference to the policy makes clear this isn't you have to comply with the immigration rules.
Let's look at the policy
After lunch. Yes.
So 2:05. You're not much longer, have you?
Not much longer.
But I think
Yes.
with you and with Mr. Malik, I think it's probably sensible to take a break rather. Otherwise we'll certainly be on quite a long time.
Thank you very much.